Hey, everybody. Welcome, welcome. I think the gang's all here. So thanks for being here for our California call specifically. I know that there are lots of questions about ammo transactions, all of that, as well as, how you can be proactive and really, be involved in the regulations that are always being fought in your state. So I'm really thrilled. We've got our group from Michele and Associates here, as well as some from the CRPA. And so, gentlemen, I will turn the call over to you.
Okay, are there any federal developments that you want to talk about, Michael, before we get into California specific stuff?
So,
ATF, things
I
going
was
on
gonna
at
s-
ATF or anything like that?
is
Yeah, I can just go
anybody
over a few things real fast, and then give it to you guys.
Go ahead.
Okay, so on the last, some of you, I see a couple people might have been on the last call. I just wanted to go over a couple compliance issues that have coming up. One is warning conferences that ATF provides to you, a letter where they want you to come in to see either the area supervisor or the director of industry operations for your area to attend a warning conference to go over violations that you were cited for during their inspection. And in the warning conference letter, they want you to bring a written document with you that specifies what actions you have taken so the violations cited will not occur again. And what we're telling FFLGuard is telling all FFLGuard clients is to not take any documentation in with you to this meeting that can be utilized against you in the future. So when you go, you're going to do the same thing you did at a closing conference. They're going to bring up every single violation again, and you're going to state, what actions you've taken so that these violations will not happen again. Of course, they could happen again. It's human error a lot of times, but to the extent that it might be the extent you were cited for, maybe 10, 20, 30 violations, that these kind of things will not happen again. Taking in freaking inventories, going electronic instead of having manual records, things like that, what actions you've taken to prevent these violations from occurring again. Do not take written documentation there. Physical inventories, we talked about that also. I bring it up all the time. Brian brings it up all the time. Continue to do your quarterly inventories. And one suggestion I'm going to make is if you have the manpower available to have at least one person assist ATF with that inventory, it'll go so much faster, and it prevents the ATF from coming back to you after 1 or 2 days and say, hey, here's a list of 50 guns, here's a list of 100 guns that we could not find. If you have an employee or yourself that can go through the inventory with them, it speeds that up and eliminates a lot of issues during the inspection. Also, I want to talk about, especially for the border states, this one being California, non-immigrant alien sales. ATF is scrutinizing those very closely, looking at every non-immigrant alien transaction, especially denials. Denials they're referring on to ICE, just so you know that. But they're looking at those, and they're looking at any denials of firearms. They're going back, we've heard a couple times, 2-3 years, looking at denials, looking for any straw purchases, suspicious sales that are going, especially again to Hispanic. They're not going to say they're looking at it, but they are. They're looking at Hispanic purchasers without a doubt. Also, coming up this fall, everybody should be aware that we have been notified by ATF that they're going to have a lot of rulemaking coming down the pike. Rulemaking regarding the importation of firearms and rulemaking regarding manufacturing of firearms. They're going to do a lot more changes regarding manufacturing / gunsmithing. What we've heard from a very good source within ATF, and a very good FFLGuard source within ATF, is that, say, Cerakoting is going to be taking off the list of manufacturing. So you may not need a license anymore to Cerakote firearms. So there's a lot, and from what we heard from this source is it's a lot of good changes that the firearms industry will be happy with. So we just got to be aware to be looking for these changes in the fall when the rulemakings come out, and to keep you all advised to what's out there and what the government's proposing to help you, it seems like, in the future. So those are some things I wanted to bring up before you guys get started. Chuck, unless Alexis wants to comment on anything.
Just quickly, for those of you that were not on the federal call, access to the NCIC stolen gun database is now available. You don't have to be in a state that uses FBI NICS as your contact. So obviously, California point of contact state. You can still sign up to access the stolen gun database. You will need to register for an eNICS account in order to gain that access. Just important to note, because FBI NICS, last time we spoke, they weren't 100% sure that the link to run a background check was not going to be there for those that are in a point of contact state. Be sure that your team does not attempt to run background checks through FBI NICS, through the eNICS portal. Be sure they understand that doesn't change. That the stolen gun database is all they should be accessing. And again, like we said before, give strict written documentation of when and how they should use that. So if you have any more questions regarding the stolen gun database, please put in tickets. We'll definitely speak with you about everything we know about it, which is honestly not as much as we'd like. But biggest topic to know is that when you input a serial number, Arabic numbers and American alphabet letters only. No spaces, no hyphens, no other fun characters that in those custom serial numbers that some manufacturers use. All of that is left out. If it's over 20 characters, they ask you start with the last 20. If there's no response, then do the first 20. The magic number of 20 comes from the fact that that is the size of the field in the database, right? So that's why it's 20 only. So honestly, if you're looking at something that's over 20 characters, please be sure you're actually looking at a serial number. But again, any more questions, thoughts, please reach out, put in a ticket. All right, because I know this is kind of repeat for most of you, but that's all I got.
Okay, so Matt and I will sort of tag team first on litigation developments and whatever actions are going on at the DOJ, regulatory actions at the Cal DOJ. And then I'm going to have Rick Travis, who is the legislative advocate for government affairs at CRPA, who is in Sacramento and has gotten some amazing things done this year, stopped some really bad stuff, and got the first pro Second Amendment bill, loosely characterized, passed in the Capitol in decades. And then I'm going to have, and Matt, Rick is an asset and a resource for FFLGuard YSP clients. And then I'm going to have Kevin Small, who is the grassroots outreach. Kevin, what's your actual title?
Advocacy and Outreach Director.
Basically, our grassroots guy runs a number of different programs that I want for CRPA programs that I want you guys to be aware of. Because as I'm about to explain, the CRPA is kicking ass in California, and there are programs and things that California FFLs can do to help support CRPA that don't cost you anything, and that would really help us bring more lawsuits and stop more bad bills and oppose more Cal DOJ regulations, which make our lives more difficult, not less difficult. But so I'll start with the lead, which is the Rhodey result. First, let me actually give you a background here for a minute. So for over 20 years, NRA and CRPA had a joint partnership where we co-funded 4 different programs: range and retailer protection, legislative analysis, local ordinance advocacy, usually opposing a bad gun bill, but now we've actually shifted over to pushing some positive resolutions in certain pro-gun localities, and then hunting and conservation. When the NRA ran into all the trouble that it ran into, and it was quite a bit, it drained their legal trouble because, frankly, Wayne LaPierre was robbing the till. No other way to put it. Jury said so. The NRA wound up spending $200 million or more on a lawyer who I don't really have a lot of respect for, to tell you the truth, that billed them $2,000 an hour and basically churned that litigation, churned that lawsuit, even after the judge said the Attorney General of New York was looking for the corporate death penalty. She wanted to put the NRA out of business. When the judge said that that was off the table and the NRA was going to survive, that case should have settled, because it ultimately resolved on the same settlement terms that were pretty much on the table years and years and millions of dollars in legal fees ago. Bottom line, though, out of this is, for 20 years, CRPA and NRA were working together. When NRA had to spend all its resources on legal defense for corporate issues, it cut off all funding for California programs that it had been doing with CRPA, with the exception of the appellate work on Duncan, which is the magazine capacity lawsuit, and Rhodey, which is the ammunition background check and ban on internet sales lawsuit. So CRPA was faced with a decision. It could either dismiss 10 other lawsuits that it had going, where CRPA was a named plaintiff and several individuals had volunteered to give us to join the lawsuit to give us standing at a potential cost of invasion of privacy, as the state did discovery on the standing and the status of the individual plaintiffs and the CRPA as an associational plaintiff. So we could either walk away from all that, abandon it because NRA wasn't going to fund it anymore, or we could raise our own, step up, raise our own funding, and become a standalone entity. The CRPA is still the state association of the NRA, but that means almost nothing. CRPA has its own board of directors, its own committee structure, its own bank accounts. It gets no money from the NRA directly. The only thing the NRA does is pay the lawyers on Duncan and Rhodey on the appellate work, which is Clement and Murphy. So CRPA sees nothing from NRA anymore and does not fund any of the programs or lawsuits that CRPA now funds on its own. That's been going on for 6 years. In those 6 years, CRPA has gone from 3 employees to 17. It's now got 50 local chapters around the state who are doing the Lord's work at the local level. Far better job than was ever done by CRPA and NRA working together through NRA members' councils. And we are doing our own legislative advocacy, which Rick will tell you about in a minute, in Sacramento. And when it came to hunting, which frankly NRA never really did much for, CRPA led the charge to form the Hunting and Conservation Coalition, which Rick can tell you more about that too, where we have all the main hunting groups working under the same umbrella of the HCC, Hunting and Conservation Coalition. And now as a combined force, they get a lot more done than anybody ever did when they were working independently of each other. So they're coordinating their efforts. And one of the programs that CRPA has created is its business affiliate program. And that's what I'm going to have Kevin tell you about, because you should all be business affiliates. Okay, so to the lawsuits. The Rhodey v. Bonta lawsuit is the challenge to ammunition background checks and ban on interstate sales. We just got a ruling out of the Ninth Circuit 3-judge panel that said that that law is unconstitutional and struck it down. You guys may remember a few years ago, we had Freedom Week when we got a ruling in the magazine capacity limitation case, the Duncan case, where the state was not on top of getting an injunction or getting a stay on the injunction, I should say. We had Judge Benitez, AKA Saint Benitez, give us a judgment in our favor in Duncan. And while the injunction was in place, the state appealed, but the injunction was not stayed while they appealed. So for a week, we had Freedom Week. Millions of magazines came into the state. I still have a great picture from Bass Pro out in Nevada, where the magazine rack is just empty, because they were all being shipped to California to fill the pent-up demand that was going on there. Well, we had a similar result for a few days, even though, as a legal matter, the stay on the injunction was not lifted by the decision of the 3-judge Ninth Circuit panel. In other words, the law was still in effect. But try telling that to a frenzied group of folks who are doing jumping jacks because now they can buy internet ammunition. And so Brownells and Midway and a number of other ammunition retailers from out of state and in state started selling ammunition without going through the background check. NSSF came out and said, you can't do that. I tried to tell some people that, some clients, but they said, if I take that position, I'm going to get crucified for being a traitor to the cause, which I completely relate to. But I'm just the messenger, man. This is the law, or what the law was. Finally, DOJ came out on Monday. So between Thursday and Monday, people were selling ammunition. Finally, DOJ came out on Monday and said, stop. The law is still in effect. And so everyone, as I understand it, at least, has stopped selling ammunition without doing the background check and whatever else is required under that law. So now the state will absolutely 100% certainly ask for en banc review, because that's the game they play. They want to get in front of an en banc 11-judge panel because it's basically another roll of the dice. It's not the same roll it used to be, because it used to be 2-to-1 progressive judges versus Republican appointees. It's now about 50-50, and we've got a couple of real proactive, aggressive judges on our side up there now. Judge Van Dyke stands out amongst them as one of the most vocal in condemning his colleagues for not following the proper standard and methodology that the Bruin decision requires. So they may not get a majority of anti-gun judges on the en banc panel, but they're going to give it a try. Win or lose there. If we lose, we go to the Supreme Court, and this is a case that checks all the boxes for Supreme Court review. The Supreme Court's not looking for preliminary injunction appeals called interlocutory appeals anymore. They're looking for cases that have been tried, that have a completely developed record, and that have all the expert testimony and all the information that they need to fully address the issue, not in a vacuum, but with the body of evidence that was presented at the trial. Now, Rody has been tried twice in front of Judge Benitez, and we won twice in front of Judge Benitez. Same with Duncan, by the way. It's been tried twice. So Rody will have to play out, and we'll see what happens with en banc review. We will fight the request for en banc review. If it's granted, we will fight in the en banc court, file additional briefs there, do whatever needs to be done to try and convince the en banc panel that they should strike down this law. But we don't know what the panel will be, so we can't predict really what the results will be. So, but anyway, the bottom line in the meantime is the law is still in effect. So you still have to do what you were doing for the background checks for ammunition sales. On the Rody case, but we need help there because there's work to be done, whether it goes to the Supreme Court or not. The en banc panel is still a bunch of work. So we're fundraising off that as best. CRPA is fundraising off that as best we can. I'm doing media interviews. My quote was in like 1,000 newspapers because the AP, the Associated Press, picked it up. So there's a lot of people aware of it. We are raising more money, but we need it's going to be a long, drawn-out fight. And we have other cases that we have to fund as well, like 10 of them, trying to work to protect your Second Amendment rights. So Duncan is the next high-profile one. That one went in front of the en banc panel for a second time. And that's a long, tortured history, which I won't get into the details was. Suffice it to say, we won in front of Judge Benitez. We went in front of the 3-judge panel. We won. We lost in front of an en banc panel. This was prior to Bruen. We went to the Supreme Court. The Supreme Court held it till Bruen came down. Once Bruen came down, the Supreme Court remanded it back down to the en banc panel. The en banc panel remanded it back down to Judge Benitez. Judge Benitez said, we win again. We went back up. And lo and behold, the en banc panel stole it from the 3-judge panel. And this is where Judge Van Dyke went nuts and went back in front of the same en banc panel that we heard the first time around, where we lost 7-4. And gee, what a surprise, we lost 7-4 again. So now we have a cert petition in the United States Supreme Court for them to hear that Duncan case. It again checks all the boxes for Supreme Court review because it's a final judgment twice. It's magazines. To be honest with you, I think they're afraid, a little bit nervous about an AR-15 case because of all the false narratives that have been developed about what an AR-15 is, and then whether it's a fully automatic or a semi-automatic. And it's easy to blast it in the court of public opinion as opposed to the court of law. And sometimes Supreme Court doesn't want to jump in the middle of that. Now, they turned down the Snopes case, previously the Bianchi case, which was an AR case, and they turned down the Ocean State Tactical, which was a magazine case. But the Ocean State Tactical was a preliminary injunction appeal, and the Ocean State Tactical had some holes in the record too. So, but in the process, they said, we're going to have to take one of these cases. And then in the Mexico case, Mexico versus Smith & Wesson, Judge Kagan, believe it or not, said that you can't say that just because criminals use a certain firearm that it can be banned because law-abiding citizens choose to use the same firearm in overwhelming numbers beyond the criminals. So that rejects a huge argument that the gun ban lobby has been making. And when I say the gun ban lobby, I'm talking about Bloomberg and Everytown Law and Giffords in San Francisco. And Bloomberg is spending millions and millions of dollars. His funds are unlimited. And then they put taxpayer dollars on top of it to fight us. So they have both a private and a public war chest to use against us, which is why we have to keep beating the drums for fundraising. Anyway, so the Duncan cert petition will be filed August 18th. We are working with the United States Department of Justice and the Attorney General's office to get them to join us in asking the Supreme Court to take the case. And I expect that they will file a brief in the Supreme Court saying, yes, you should take this case, Supreme Court, which increases the chances of them taking the case by about 10, a factor of about 10. So that's good news. So those are the two big high-profile ones that are in motion. But the other big fights that we're having, we just finished knocking out the ban on marketing to minors. So Bass Pro can put the teddy bears with the I Love My Daddy the Hunter t-shirts on them back on the shelves that they had to take off because that law banned anything to do with the shooting sports that might be attractive to minors. That's how ridiculous it got. So, and basically, that extreme example aside, they basically shut down the shooting sports because everybody was afraid to have any kind of an event where they might have something that could be considered attractive to minors, whatever the hell that means. But now they're all back in business because we had to go up. The state tried to claim that the first injunction we got only covered part of the law and they could still prosecute people for some marketing. We had to go back up to the Ninth Circuit. The Ninth Circuit bitch slapped. The trial judge said no, this, and the DOJ especially, that was a fun argument to watch, and said, no, what kind of sharp tactic is this? We said the law's unconstitutional. It's an infringement on the First and the Second Amendment. The entire statute is enjoined. So junior sports have been saved by the CRPA. And those are future senior shooters and folks that are going to be, activists and customers down the line if they're not already because their father's buying them a shotgun. anyway, so that's the junior shooter sports. We're fighting gun shows. We're fighting the roster. The roster is in the Ninth Circuit, right, Matt? I'm forgetting.
Yes.
It's held up behind Duncan, I think, still, but we might get a decision on Boland, the Boland case challenging the roster any day. We've got a challenge to the excise tax, which we've been working with another law firm, Clement and Murphy, not Clement and Murphy, Cooper and Kirk, and they're in Illinois or DC, and they're kind of leading the case for local counsel. They did not go to the when you challenge a tax law, you have to challenge it administratively before you can sue them in court. You have to exhaust your administrative remedies and appeal it within the department first. And they didn't do that. So the state said, hey, you didn't exhaust your administrative remedies. So this lawsuit in federal court is not ripe yet. So now they're in the process and they're almost finished exhausting the administrative remedies in the tax bureau, and then they will refile the excise tax challenge and move it along as quickly as they can. But we are working to shut that down. We're also working to shut down the video requirements that FFLs have to use, working with GOA and GOC on that one. The CRPA is partnering with them. And then CRPA versus LA County Sheriff. This is on CCWs. Jurisdictions continue to try, some recalcitrant jurisdictions that are still trying to enforce the policy that they had for years, even though they can't use good cause anymore. They're trying to make it as expensive, cost as much, and take too long to get a CCW. So we sued Laverne because they were charging too much. They dropped their fees and settled. We're still in the middle of processing of suing LA County Sheriff. We're in settlement discussions with them to try and reduce the backlog. We're encouraging them to bring in private vendors that can process those applications. I think they have about an 8,000 application backlog right now. And they're supposed to process them all within 120 days. They're pleading poverty, and we're like, hey, tough luck. We didn't create the system. You created the system. If you don't like it, go change the system. In the meantime, you got to spend the money to process these applications. So that's making headway. We've sued DOJ, Cal DOJ. They're about to settle to create an out-of-state a process for out-of-state residents to apply for a California CCW statutorily, even though right now, because of the injunction that we got from the trial court, out-of-state residents can apply. So that's happening right now. And departments are scrambling to try and figure out how that process should be set up, system. But that's a win against DOJ, a win against Laverne, and soon to be a win against LA County Sheriff. And then next is LAPD. I'm in discussions with some of their vendors, telling them, look, if you clean up your act, we won't sue you. And we don't want to sue them until we see all the things that LA County Sheriff tries to use for their defense, so that we're forewarned and forearmed against whatever LAPD might bring up. But LA County Sheriff just tried to have our whole case thrown out, and the judge told them, go pound sand, the case goes on. So that's another procedural win. Santa Clara is next over their high fees. I talked about Duncan. I talked about Junior Sports Magazine. May v. Bonta is our SB2 sensitive places case. It was a mixed bag. And now we're back down in the trial court trying to get more, quote, cases that the state deems as sensitive places where your CCW license is invalid, trying to get more of those struck down. And then Rupp v. Bonta is CRPA's semi-auto AR-15 case. FPC has a Miller case. Those cases are getting consolidated in the Ninth Circuit, and I expect that will be held for a while, along with Boland, while they see what happens with Duncan. And there's a couple others, but they're not as significant, so I won't go into them. The point is this: we got a full plate. NRA is not kicking in as any, except for two. Oh, and also we have all the programs. We have our junior shooting program, women's shooting program. I'll let Kevin and Rick tell you more about those. But so CRPA is funding a lot of things. Now, I don't usually get on here and pimp CRPA too hard because this isn't a CRPA platform. But then again, on the other hand, every FFL in California, and Rick is going to tell you about the high spot on this, how a couple things happened for FFLs just this session, is benefiting from the CRPA and our programs and our activities. And you guys, it doesn't cost you guys anything to support the CRPA and help make people aware of its existence and to join it. And so with that, I think I'll let Matt, if he has anything on DOJ regs, weigh in, and then we'll go to Rick.
Yeah, so I'll be brief. There's two sets of regulatory packages currently pending in front of the California Department of Justice. The first being the regulations concerning CCW licenses and implementing a lot of the final changes as a result of the enactment of Senate Bill 2. There was an initial proposal a while ago that they now have come back and they have introduced a modified proposal following the 45-day public comment period that they first had. And so there was a shorter 15-day public comment period on the revisions that they just posted that ended on July 23rd. So depending on how long DOJ takes to review those additional comments, I would expect we will see that proposal get finalized here shortly. Included in that proposal is, of course, the changes to the entities that can provide the required training to become a CCW instructor, which will now also include CRPA's training program, which I know we don't have Jerry Clark on the call here today, but that will provide another avenue for individuals to become instructors for the CCW training requirements by becoming CRPA certified instructors themselves. Besides that, there is the proposal, of course, that's more directly applicable here to dealers, and that is, of course, the proposed regulations concerning civil fines for violations following inspections. That had a 45-day initial public comment period that ended here on July 22nd. So I would imagine that DOJ is probably going to take a few months to review those public comments, and we will see what DOJ does with that proposal. And of course, as soon as either of these proposals get finalized, we'll be sure to notify you guys and then go over what the actual specifics will entail. The only other thing that I wanted to mention regulations wise is, of course, there was and I don't think we talked about it earlier, there was the proposal from the federal government concerning the rights restoration process for individuals that are currently prohibited from owning or possessing firearms. That is likely to have some substantial impact here in California for individuals that have offenses that, for example, could not otherwise be reduced to a misdemeanor or have certain misdemeanor prohibitions, things like that, that trigger federal restrictions. And so we are waiting, of course, to see where that ultimately ends up, but that will provide an avenue for individuals that are subject to a federal prohibition to potentially have their firearm rights restored, which under current federal law and statutory issues, there has been a mechanism that's been in place. It's just Congress has not funded it for decades. And so that has typically been barred, or at least closed off, I should say, to individuals that are suffering a federal prohibition that would otherwise potentially be eligible. So just waiting to see what happens with that. But obviously that could potentially impact FFLs here in California, at least indirectly, by potentially opening up, again, customers that were previously prohibited for any reason. And so we will be paying close attention to those and be providing more information as that becomes available.
That is a service that our law firm will be providing, by the way, to walk people through that rights restoration process.
Yes. And so with that, pass it off to CRPA.
Yeah, Rick, tell us about all the good things happening in Sacramento and the bad things, the good, the bad, and the ugly.
Hi, welcome everybody. Rick Travis, Legislative Director for the California Rifle Pistol Association. I want to give a little bit of a background on what CRPA does when it comes to defending your rights and those of your customers. We do have been responsible for putting together the largest group coalition of people inside the hunting and conservation group. I'm one of the two co-founders of what's known now as the California Hunting and Conservation Coalition. We meet with the department, Fish and Wildlife, and the Game Commission to try to stop bad legislation first. Secondly, to correct regulatory issues. And then when we can't do that, then we bring a lot of pressure on both of those agencies. Right now, we're currently fighting the predator policy issues involving everything from bobcats to coyotes to bears to wolves, along with mountain lions. So several bills were brought forward from that. The other thing we did was I got involved and decided that it was time to change the Outdoor Legislative Caucus. It had really become more just a group of people that got once a year and had a drink and said, wow, that was fun. And so we completely overhauled the caucus, set up a brand new advisory council comprised of people like myself that are in the business of making sure our rights are maintained. And that caucus now has 36 members of the legislature. And one of the Democratic co-chairs, she actually is from Oakland. She went out shooting, limited out on her ducks the first time, has become a very strong voice in the community. And so we are bringing forth some really powerful legislation. One of those, which I think people on this call will understand, is we have been outpaced in this industry for years with public information, public control. And so the Outdoor Sporting Caucus is bringing forth a bill that I helped co-write that will set up a wildlife council in California. And that council will be funded with about $6 million annually to put out scientifically based messages to the public so that the public cannot be duped or hoodwinked anymore moving forward. And so that is my segue to what I've been trying to do for FFLs. Have worked very closely with Matt Cabero. A lot of times we're attached at the hip. And so Matt looks at the legal issues and then I go in and tackle them inside the Capitol. And one of the things that we're trying to do is reset the terms and the definitions throughout. And so you're going to see some bills coming out in January on that. But this year, what we tried to do was relieve some pressure on FFLs. And many FFLs, as you know, in California, had been caught between the penal code and the fire code in regards to their security doors, which was absolutely inane what was being done to you. And it depended on, the whims of DOJ, when they enforced, when they didn't enforce, who they did it against. And that caused some FFLs major issues with their landlords and other people. So Matt and I worked on it. We wrote a very tight bill, ran it through Ledge Council. And this will show you two things. Number one, what I've been saying for the better part of a decade, organizations like the CRPA and FFLGuard can run legislation, get it passed in California. We just have to be tactical the way we do it. The second part was it's time for us to get aggressive and time for us to work collectively together. And I'm going to let Kevin talk about how that happens. But one of the things Kevin and I do share is he has an amazing program statewide that he has crafted over the past few years of chapters. Within those chapters are legislative teams that I work with. And we actually go to the Capitol once a year. Now it's going to be twice a year. We have our women's program called Women Armed to Vote and Educate. They will descend on the Capitol in January. And as a result, we were able to get Assembly Bill 584. But to the disdain point was when I first went to go meet, we go to public safety. That's where all bills go to die. That has been the montage for 30 plus years. This bill was ran so tight that I got a call from the head of public safety who said, there is no way this is going to see the light of day. And I said, but it has to see the light of day. And so after discussion, it went on what's called consent calendar. If you're not familiar, in the Capitol, consent calendar are usually items that we don't need to talk about because, well, we kind of all agree it just needs to move forward. And so Assembly Bill 584 went on consent calendar with a recommendation to every other policy committee in the Assembly to do the same. I called Matt and I said, this will be unbelievable if we get to the floor. When it got to the floor of the Assembly, the Speaker of the Assembly said, yeah, I agree with everybody else. They put on consent calendar. So the bill passed with unanimous bipartisan support out of the Assembly, a 2A bill in California. Then it went to the Senate, spoke to the head of the Senate. The same plan was carried out again, went to the governor's desk. We tried to get meetings with the governor, tried to get meetings with his staff, couldn't do it. And finally, one of our friendly members, we have two within the governor's office, called us and said, yeah, he signed it about 5:30 today. It's not going to be no fanfare, but it's done. So we got the first bill across, which means now you guys are no longer held to this. Do you listen to the penal code or listen to the fire code? You're now able to get the security doors that you need to provide what you need without fear of being fined or being gone after. And so the first 2A bill was an FFL bill, which shows our dedication to everybody here on this call. We have several other bills that are coming up. We fight bills for one of the ones, 1092. We're trying to get that back up and out. I'm actually meeting with the member on that this week, and that bill will take us from 2-year renewals and initial CCWs to 4 years. There are a lot of obvious reasons we all want that. And we have several other bills dealing with wildlife, hunting issues, and things like that, where we can always use FFL's help is getting that good word and that good news out to as many people, because the more people calling into the Capitol, the more people using some of the programs Kevin will discuss, the easier it makes my job. But I want to send this message clear. We do not fight defensively at CRPA. We fight offensively, and we are going to be able to continue to get bills across. This wasn't a one-off. This is just a beginning. And with the different things that we've worked for the past decade to put in place, those are all coming together all at once.
Rick, what about the other bad bills like the Glock bill and what's still out there looming that threatens us?
Yeah, there's 6 bills out of 71 that were brought against us. So I want to make that really clear. Out of the 71 bad bills, there's only 6 left. So that's a pretty good batting average this year. The 3 that I think are of the most concern, obviously, is Assembly Bill 1127, which has been called the Glock bill. We need to get the message out there that this bill brought to us by Assemblyman Gabriel, same person gave us the excise tax. What he has done is he's just trying to go after a manufacturer. It really has nothing to do with what's called the Glock switch. And I'll tell you what, that's where he's trying to get everybody to look, is because in testimony, both myself and one of my colleagues on several occasions brought up the fact that we could simply remove the Gen 3 Glocks, put Gen 5 Glocks onto the roster, and that would resolve the whole issue with the Glock switch. And they refused to do that because this isn't about public safety. It's about trying to take a manufacturer off the list of what can be sold in California. And so that is the message that you've got to send to all your customers and get them on board. This may die. It's in appropriations right now. It may die in appropriations because if you haven't heard, California's budget is really, really bad, approaching triple-digit billion-dollar deficit. And so as a result, we may be able to kill it there. But if not, I'm sure when it gets to Chuck's desk, if the governor does sign it, which he may not because he's trying to run for president, but if he were to sign it, we're going to litigate that one. The 2 other bills that are really bad, we have a bill that's called a ghost gun bill. It's going after CNC machines and 3D printers. We're fighting that one. I don't know if that's going to make it out. There's some financial issues. There's a lot of talk. 1263 may not make it out by Assemblyman Gibson. And then the last one is going after Senate Bill 720, and that is dealing with firearms barrels and trying to set up a scheme where you would have to have all your firearms barrels registered. The federal government says they're not going to participate in it. So for that reason, the governor would most likely veto it. But that's where everything kind of lays right now.
All right. So as you guys can see, Rick has his hands full. I got to give a hat tip to Sam Paredes at GOC, who works with CRPA. NRA has a lobbyist there, but sadly, NRA's brand, a part-time lobbyist, I should say. Rick and Sam are both full-time. Sadly, NRA's brand is so badly damaged that some legislators won't even take a meeting with them. So CRPA is really making a lot of headway that we really didn't make even when CRPA and NRA were working together in the Capitol. We're going proactive and building coalitions and reaching out to even the, like the Blue Dog Democrats, the more moderate Democrats, is paying off. We've stopped a lot of bad stuff. David has a question about the new microstamping bill. Rick, you want to talk about that for a minute?
There is no microstamping bill that's alive right now. All those bills are dead that were brought forward. I'm sure it will come back again because it's one of those zombie bills that comes back every year. But currently,
so the background there is CRPA's lawsuit against Bolin found microstamping was unconstitutional. So the state declined to continue to defend the microstamping component. So as of now, you don't have to have microstamping to get on the roster. You still have to have the loaded chamber indicator and the magazine disconnect safety, so-called. But this has made it possible for a few new guns to get on the roster. But rather than defending it in the lawsuit, they said, screw it, we'll just pass a new bill. Well, then they didn't get the new bill passed. So they'll try again because they're basically taking a different run at microstamping. And the DOJ just recently published their required study that says that microstamping is technologically feasible. Never mind that it's completely impractical. And if they ever did it, a manufacturer would have to send the gun to some kind of a gunsmith that would retrofit a gun with microstamping, not thereby voiding probably the warranty, the manufacturer warranty, and creating a number of other problems in terms of tracking that. Another big administrative bureaucracy that the DOJ will mismanage and screw up. So we're fighting it. It's going on. So any other questions? I'm seeing a couple of questions come through on legislation or regulations. I'm looking at the chat now. I don't see any more. Okay, so all of this is a buildup to, and again, I haven't been comfortable in the past, like really trying to push CRPA. I am the volunteer president. I do all my work pro bono, including the legal work. My lawyers charge, but I do it free. I bill on other cases in the office, which, by the way, we are a full service law firm. So if you have any kind of a legal question, helpdesk@michellelawyers.com or any kind of law, not go through the YSP platform for gun law questions. But if you have clients or customers or whoever that are looking for legal help, we do free consultations on any business litigation or environmental issues. We do a lot of range protection that involves environmental issues. So, help us out. If we get business at our normal rates, because our rates for the nonprofit CRPA are very low, some of that profit can get rolled back into doing more pro bono work for people who are in trouble or for groups like the NRA. The mag ban, I see a question about the mag ban. That's the case. That's the Duncan case that's going up to we'll be filing a request for the Supreme Court to review that decision on August 18th. We lost in the en banc panel again, 7-4. And that's the infamous video dissent published by Judge Van Dyke, which everybody should watch. You can Google that because he got up there with his gun collection and showed how a magazine works and how all the different parts come together and why you can't say that a magazine is not an arm. And that's the big fight. And I don't want to get too into the weeds on the legal analysis of Bruin, but the first step is the conduct that's being challenged covered by the text of the Second Amendment, the right to keep and bear arms? And that doesn't just include hardware. It's all the associated activity, acquiring a firearm, acquiring ammunition, going into the range, going hunting. It's not just self-defense. It's all the associated activities that go along with owning a firearm. So the first step is very simple. Then the second step, and very inclusive, very broad. They try to narrow that. They say a magazine's not an arm, a suppressor is not an arm. So it's not even covered by the Second Amendment. Then the second step is, if it is covered by the Second Amendment, the burden of proof shifts to the government to prove that there is some historical law that's similar enough to the modern law that would indicate that the founding fathers would have tolerated the modern law. And there aren't that many. That's another project we've been involved with because a lot of these anti-gun groups have been publishing all these historical laws, but they put them in there out of context. They'll say, oh, it was illegal to possess a Bowie knife, so you can ban assault weapons because that was assault knives. Well, no, it wasn't illegal to possess one. It was illegal to carry one. So these are the kind of things that they leave out. So one of the other projects we did is with the Wyoming Law School of Wyoming was develop a complete list with sources to the original law. Okay, I'm getting too weedy. Yes, you're still able to possess magazines. You can't acquire new ones. It's status quo. The law that originally it was a ban on acquiring new ones, but you were grandfathered in if you had one. Then they passed a law that wiped out the grandfathering, which we knew they were going to do when they passed the first law. And so that portion of the law is still enjoined. You can still possess magazines that were acquired legally, either before the law in what, 93, Matt? I forget, or during Freedom Week. But anyway, if you got it,
2000, sorry.
Okay, if you got it legally, you can keep it. You can't get any new ones. Okay, so I was saying, you know, it's just such a no-brainer now that I ran this by all the folks at FFLG, and they're like, yeah, let these guys know. And so Kevin is going to go next and tell you about our programs that FFLs can be involved with. And at some point, if you guys, you know, give me a thumbs. We don't have to do this. If you want to focus on just, you know, California specific stuff, you know, we don't have to have Rick as he's a resource. He's something that we're happy to provide information to through FFLG. But if you would rather not have it, let us know. But if you like it, you know, give us a thumbs up someplace so we know that we should keep doing this. We could have Rick back every time there's a development in the legislative session to give us a little update and kind of keeps you guys in the loop on what might be coming down the pike. Okay, I'm vamping. Kevin, tell us about business affiliates and whatever else you think might be of interest.
And guys, 1 sec,
Brian.
Kevin, I'm sorry, I don't mean to rush you, but Teams will cut us off in 3 minutes at the 1 hour mark.
Oh, shit.
So I don't know
So
if you want to invite Kevin back for September 8th.
Well,
and
just hit business affiliates
your
real
points. Quick. Yeah.
Actually, we'll send out an email about this to all you guys. But Kevin, hit as much as you can in 3 minutes.
Just really quick. Yeah, I mean, Chuck talks about the necessity for litigation. Rick talks about the necessity for legislative advocacy, and the affiliate program can really help connect both of those things. The basic points are this can be mutually beneficial by CRPA using resources to drive people to your stores through things like our online tools or creation of events or anything like that. While where these customers are coming into your stores, you can help connect them to CRPA resources, which in turn allows them to advocate for the Second Amendment community, which includes FFLs. We've seen a lot of positivity. We've seen a lot of transferring of people from finding out about CRPA to working in a local chapter, which in essence tears down regulations that localities want to make. So there's a lot of positivity that can come from turning customers into CRPA members and Second Amendment advocates, not just for the FFLs, but also for the 2A community at large. We've got links and resources for this on the CRPA website. It is not a paid membership. It is just an affiliation and a partnership that can be mutually beneficial for affiliates as well as CRPA to turn people into advocates in legislation and litigation.
I am posting something on the chat right now about this program. You guys can reach out to Kevin and get more information, but it doesn't cost anything. Please, you just put some brochures in your window or on your counter or wherever. You can even become a recruiter and get a commission for selling CRPA memberships. So, Kevin can deal with you guys individually. Just reach out to him through his email address, which I just put in the chat. Or it's available on the CRPA's website, crpa.org. Can we stay on the chat after Teams cuts us off and answer questions, or?
Well, I'm not that sure. We've never really hit the hour mark before. I never got the 5-minute warning from them. So I guess we're going to find out in 1 minute, Chuck.
Basically, what the dealer does is just make CRPA memberships available. There might be some signage if you have space, and people can join. And if you want to sell memberships, Kevin, am I wrong? They can become a recruiter and actually get a commission.
We do have a recruiter incentive program that would see 9% of CRPA membership sales go back to the affiliate to incentivize getting those memberships, and ultimately, these memberships, like I said, they turn into advocates. We've had CRPA advocates send 85,000 emails in the legislative session of 2025 to their elected representatives for good legislation and against bad legislation. And where the legislative advocacy starts, these CRPA members with their membership and their donations end up funding the lawsuits as well. So it really is a 360. It's an investment for any of these affiliates, to make CRPA members that in turn end up advocating for them.
Yeah, so guys, it's a no-brainer. I hope you'll all become business affiliates, help us build our legal war chest and support the programs, and do all that we can do to make you guys more able to sell more stuff, at the bottom line for you. Not to mention the fact that it's a historic time for Second Amendment freedoms and Second Amendment jurisprudence. And we will win. We will strike down most of the laws in California. I can't wait till my book is no longer necessary. It's going to be a little brochure with about 10 laws in it. We will have we will get back the Second Amendment freedoms that the Democrats have been spending the last 2 decades taking away from us. So, Kevin, you want to give them your email address? They can reach out to you directly, just in case.
Yeah, I'll post it in the chat. I'll post a couple emails that you can reach out to if this is interesting to you.
They can still access the chat after the seminar closes, right? Yeah. Okay.
Yes. And definitely September 8th is what we're shooting for next. So Kevin, we definitely like to have you back.
Sure. Get into it a little more.
And get the full spiel. But we definitely appreciate you guys. Chuck, you're looking good as per usual, buddy. And September 8th.
I'm sacrificing young children and drinking their blood to stay young.
Hey, whatever you got to do. I'm in a rocking chair now, if you can't tell, it's, we're getting there. But September 8th is going to be the next meeting. We appreciate everyone coming in. The chat will stay live and the videos will be up within the next couple of days for everyone to come back and review. Thank you for joining us. Thanks, Rick. Thanks, Kevin, for coming on.
Thanks, guys.
Thank you.
Hey,